Okay, so we'll get started. So a very warm welcome to our latest Research Network meeting, the first of 2021. We're delighted to welcome Professor Rebecca Sandefur today, who will speak about legal services from non-lawyers, both human and digital. And I'll introduce Becky shortly. But first, Victoria Law Foundation acknowledges the traditional custodians of country, wherever you may be joining us from. The officers of the VLF sit on Wurundjeri land, and we pay respect to their elders and to all generations of Wurundjeri and other First Nations people, and acknowledge the lands were never ceded. We recognise the impact of colonisation, its legacy of injustice and marginalisation of Aboriginal and Torres Strait Islander peoples, and we believe that acknowledging the past is an essential step in building a better, more equitable future. All right, so just before I introduce Becky, I'll run through some brief housekeeping. So only panellists can be seen and heard in this webinar. All attendees' videos are turned off and the audio is muted. But if you can use the chat function to introduce yourself and make comments, that would be great. And also, please use the question and answer function to ask questions or for other questions, and there'll be time to get to these at the end of the presentation. We're also recording the session and we'll distribute it after the event. So we're delighted to welcome Professor Sandefur, who's one of the world's foremost access to justice scholars. Becky's biography was sent to you in the invitation to the event, and I won't read it out or try and summarize her research career, but I will take the first line of her biography, which is telling that she investigates access to civil justice from every angle. So from my point of view, Becky's research combines empirical excellence, theoretical insight, and most importantly, practical application. It brings new thinking to critical access to justice questions. It challenges our preconceptions and practices. And a lot of it is what we think of as classically ground up or bottom up. So focusing on people, how they experience issues. It looks at how they perceive and respond to problems, and how those providing legal and, more importantly, other human services might better respond both individually and together. However, it also paints a picture of access to justice as systematically unequal, based on willingness to seek advice, ability to pay, and propensity of services to deliver the help needed. So as Becky puts it, where socioeconomic inequalities become justice inequalities and geography is destiny. It also points to the need for a rethink as to how services are delivered, who delivers them and who gets what. It notes the conflation of lawyers' services with justice and reminds us that justice is about just resolution, not just legal services. In doing so, Becky's work questions the role of regulation, what role non-lawyers could and should play. And I think this is timely in Victoria, where we're seeing some, such as Justice Connect, starting to refer to the missing majority rather than just the missing middle. From an empirical research perspective, her work reminds us of the strengths and limitations of our methods. In particular, it points to the importance of rigorous approaches to quantifying what works if we want to take steps towards more democratic allocation of resources. And a lot of Becky's work's also highly practical, so at the intersection of research and policy, including recent work on court navigator schemes, which many of you will recognize as similar in many ways to Court Network here in Victoria. And it's work I'd very much like to see built on in Victoria. So needless to say, our principal researcher, Hugh MacDonald, and I are big fans, and Becky's work's been influential in defining our research agenda here at the VLF. We're also delighted that Becky's working with us alongside Professor Pasco Pleasance on our Public Understanding of Law Survey, or PULSE. And for those interested, we've now appointed a fieldwork company, Roy Morgan, and we'll speak to around 6,000 respondents across Victoria about their understanding of and interaction with law and legal problems in the winter. And you can expect updates as the project progresses. So today, Professor Sandefur will speak on legal services from non-lawyers, human and digital, and I think provide a timely insight into a fast-changing legal services landscape, setting out some challenges and opportunities. And here I will read the description. So regulatory change, research discoveries, and technological developments are changing the way law is practiced and legal services are delivered. These changes open up opportunities to deliver legal services and access to justice for ordinary people in new ways and to people and communities historically excluded. I'll discuss some of these developments and review some of the evidence about what could work. So over to Becky.
Thank you, Nigel. Good morning, everyone. It's a pleasure to be with you today and a privilege to get to talk with you about this research. I'm really looking forward to our conversation. Let's see if I can successfully share my screen. There we go. All right. So in most of the countries that most of us are familiar with, everyone would declare an access to justice crisis. And oftentimes we think about that crisis as what courts and lawyers see. So if we have a legal aid, if your country has a legal aid system, it's underfunded for whatever work it needs to do. If your country has a court system, it's probably also underfunded for whatever work it needs to do. And many of the people who are coming to courts, if your jurisdiction permits people to self-represent, you'll have very, very high numbers of self-represented litigants. And so that's a piece of an access to justice crisis, but it's actually the tip of an iceberg. So if you look at the research done by the Victoria Law Foundation and other parts, other entities in Australia, if you look at the Paths to Justice tradition of studies around the world, what you see is that the vast majority of people's civil justice problems don't ever make it to court or to lawyers, and that the access to justice gap, so the difference between people who need help and people who get help, is much bigger than what you see when you're looking at who's turned away or who shows up at court by themselves. It's all those folks who are never making it to those services who may need assistance and aren't getting it. So in the US and in some other jurisdictions around the world, people are trying to figure out ways to provide assistance that don't involve fully qualified attorneys, whatever that is in the jurisdiction where you are. And one way to think about that is to think about it as taking the legal expertise that is embodied in a fully trained legal expert and distributing it in different ways. If you think about the substantive expertise that a lawyer has or a solicitor has, they know the content of the law, they know what the rules are and what the statutes are and what the precedents are if you're in a common law system, and then they know how to work it, right? So they know what the order of steps are, they know where to file the case, they know when to write the letter, they know which particular things to cite in the letter, and so on. So if you think about those two parts of legal expertise, if you look at different kinds of innovations around the world, they're taking either one or both of those two pieces and distributing them around to new kinds of actors that might provide assistance. And sometimes those actors are people, and sometimes they're computer programs. One of the things that we know from research on the impact of lawyers is that if you're looking at what some people call the people's courts, so these are courts where ordinary people would show up to get divorced or to be evicted or to respond to a debt collection action or something. In those kinds of courts, they tend to be high volume. The legal issues are often not particularly legally complex, although they might be very complex for the person who is trying to manage them. In those kinds of situations, at least in the US, what lawyers do is they manage process. They don't deploy a lot of substantive knowledge about the law. They deploy their understanding of how to get things done in that particular context. And one way to see this is to compare the results that lawyers get to the results that people who are representing themselves get. And if you go into particular kinds of justice problems where the complexity of just managing the process is low as rated by lawyers, so lawyers say this is pretty straightforward, it's pretty simple, there you see that lawyers, under a whole set of assumptions, the maximum advantage that a lawyer has there is about 15 or 17 times greater likelihood of winning than someone representing themselves, which sounds like a lot, and it is a lot, but it's nothing compared to what you see when lawyers think complexity pops up one level to average for legal work is understood by lawyers. So lawyers don't think this is hard, they think it's ordinary. But once you get into a lawyer's idea of ordinary process complexity, then you have lawyers outperforming people by about 150 times, again, under this sort of assumption of the maximum difference that you might see between those two parties. So it's pretty clear that complexity of process is something that is a hang-up for ordinary people when they're trying to navigate complex legal processes, and it's part of what lawyers are deploying. So when many people are thinking about how to distribute those different kinds of expertise, they think about ways to distribute process expertise or to make process expertise irrelevant, right? So that's what simplification and plain language forms are about. They're about making that difference go away by making the complexity go away. In the US context, we have a really strong monopoly by lawyers on law. So they control almost all of the practice of law, which includes legal advice, but also rights of appearance at different kinds of places. And so if you look at these different efforts, one way to think about them is, again, this unbundling model, that there's a big bundle of stuff that lawyers can do, and then we can take it apart. So if we think about a lawyer, at least in my jurisdiction, that person can represent you either in a formal setting or with the other party. They can take actions on your behalf. They can give you legal advice. They have what we call privilege. So if you tell your lawyer something in confidence, your lawyer cannot be compelled to reveal that information to someone else. They can give you legal information, which anyone can in a US jurisdiction. And then the way we credential lawyers is once you get whatever certification you require and pass the bar, you're omnicompetent. So you can practice, you are formally empowered to practice in any area of law. You can do a death penalty case because we still have capital punishment. You can do a merger and acquisition for billion-dollar companies. You can help somebody get divorced. You can do whatever, right? You're formally empowered to do those things. So that's a lawyer. And then if you look at these new efforts, they take pieces of those capabilities off and they distribute them. So one thing that you see with technology is this is a picture of a woman holding her cell phone. And on her cell phone is a picture of a dead rat in her apartment. And she's using a tool called Just Fix that comes out of New York City. And it's a much more elaborate program now, but it began as a way to write a letter to your landlord and tell your landlord that there were conditions violations in your apartment. It's a really clever tool. So it takes you through a guided interview about the common areas, about your apartment, about pests, about mold, about hot water, all those things. You answer yes to whatever's going on. Then it tells you, okay, you told me there were rats, go take a picture of a rat. You told me there was a leak, go take a picture of the leak. Then you press done. And it writes a beautiful letter to your landlord that tells, the landlord what premise this is, who you are, what parts of the housing code are being violated. And then it says, and by the way, in case you're curious, the date stamped, time stamped, geolocation stamped photos documenting that this is happening in the apartment you're responsible for are attached to this letter. And then the program ships that off as a certified letter to the landlord. So the idea is by lodging this formal complaint, you get repairs, but it's also the first step you would need to take if you're going to file a lawsuit in housing court to compel your landlord to make the repairs. This is a really sophisticated example of a non-human, non-lawyer assistant who's basically giving legal advice and helping you write a really good demand letter. Different states in the US have come up with these certificated paralegals. So sometimes I call them junior varsity lawyers. I don't know if you have junior varsity high school sports where you are, but it's sort of the people who are preparing to become the seniors on whatever team it is that's important at your high school. So they don't play in the big league, but they still play the game. So these are technicians of different sorts. They have different titles. They have limited licenses. So they can usually do part of what a lawyer can do. They often cannot appear in court, but they can do everything else in one or two areas of law. So only in family law or in family and landlord tenant or something like that. So there are a range of those being developed and deployed around the country. And these occupations are usually credentialed by the bar. So whoever it is that credentials lawyers in that state also credentials these junior varsity lawyers. Then there's a bunch of websites that provide usually information, but also sometimes sophisticated ways of filling out official court forms. Every state in the US has a statewide legal aid website, which is our legal services for very poor people. That's the extent of our legal aid system on the civil side. Every state has at least one organization that provides those services. And in every state, that organization has a website that has some general information or more, sometimes about the law. And then Nigel mentioned navigators. In a range of jurisdictions around the country, there are different kinds of non-lawyer people who are not credentialed, who are sometimes paid, they're sometimes volunteers, who assist people who have showed up in court with particular kinds of justice problems. So that particular picture is a New York City housing court navigator in the Brooklyn housing courts. There are navigator-like programs in the US in domestic violence, in mortgage foreclosure, in evictions, a little bit of family law, in different parts. Again, this is not a national program. We've got 50 states plus the District of Columbia, and they all decide what they're going to do. So there are very different things going on around the country, but non-lawyers providing a lot of process assistance in court to people who are already involved in justice problems of different kinds. What we know about non-lawyer people in the US context is that, first of all, as I said, they're what they can do is quite restricted in most parts of the US right now. So they cannot give advice. They cannot tell you which form you need. They cannot fill out a form for you, although sometimes they can scribe it if you can't write, for example. But they can give you legal information, explain to you the next steps and stuff like that. One of the things that you see when you look at these, even not very particularly empowered actors, is that they can achieve results that are as good or sometimes better than attorneys. So in New York City, there was a particular kind of court navigator that was a trained social worker who was paid by a settlement organization in the city. And those social workers assisted the same kinds of people that legal aid lawyers would be assisting who were facing eviction for an unpaid rent. They selected people who were particularly vulnerable to eviction. So they had disabilities, they had a lot of back rent, that they had a range of reasons. Maybe they weren't native English speakers, a range of reasons why it would be hard for them to participate in their own cases. They accompanied them throughout the court process. So they couldn't practice law, but they could go with you when you stood before the judge, or go with you when you met with the landlord's attorney, could help you put your paperwork together, could explain to you what the next steps were. And then they also spent a lot of time, because they were social workers, working with their clients outside of court to assist them in connecting to benefits and services that would let them reliably pay their rent going forward. So they didn't just solve the legal problem, they solved the other problem, which is the inability to pay rent, which is how they got into this position of being at risk of eviction anyways. And so when you combine that, the in-court assistance, which is not strictly legal, and the out-of-court assistance, which is very much wrapping around to some of the situations that are creating the legal problem, what you see is that at a pilot scale, they had 100% success rate. That is, nobody that they worked with got evicted. And they did that at about half the cost of legal aid lawyers. So this is a really effective program, even without empowering these folks to do anything that in the US would be the practice of law. So people can do these things quite well for I think an identifiable body of situations. If you look at those navigators, you know, you had not just differences in legal outcomes, but differences in real life outcomes. Like, you didn't have to move, you didn't have to go into a shelter, you didn't have to couch surf for a month until you found a new place. When you look at those independent paralegals, those programs are much newer. They don't serve high volumes of people at this point, but if you talk with clients of those folks, the clients like them. So at least at that sort of customer service level, there's contentment with those things. Many of the models that you see in the US context, particularly the court-based one, rely on volunteers. And volunteers are attractive because they seem like they're free, but of course they're not, because someone has to supervise them and train them. Otherwise, they sort of become very meek and won't be as effective as they can. Another thing that we saw, my colleague Tom Clark and I, looking at these different kinds of non-lawyer people who are still not practicing law, well, some of them are practicing a little bit of law, is that there's so many stakeholders from the courts, and the courts itself is the clerks versus the lawyers on the other side versus the judges versus the courtroom attorney. You know, the judges, our judges have attorneys, so the court attorney, that's one set of stakeholders. Then there are the philanthropic funders that are paying for most of these things. That's another set of stakeholders. Then there's the leadership of the court system, which thinks this is a good idea and sends out a memo saying this is what's going to happen, but no one reads that memo, right? So, you know, you have very different perspectives on what's happening here and very different levels of knowledge. And that can really undermine the effectiveness of these programs, even when they're very good. And the other thing is that these things are new. So most people understand that there are lawyers and there are courthouses, but they don't necessarily know what a limited licensed legal technician is or what a court navigator is. And these programs are typically don't have large advertising budgets, and so people don't know about them, and they tend to be somewhat underutilized, unfortunately. But there's a lot of potential there, even without empowering those people to practice law in any formal way. If you look at digital tools, it's another place where there's a lot of promise, but it actually hasn't materialized quite so well so far yet, at least in the US context. So a couple of years ago, I did a kind of a landscape survey to see what consumer-facing tools existed in the US context to assist people with justice problems. And there were 320, 330 of them. So there were a lot of them out there. They range from the one that's on the far left, which is called the Oh Crap app. And the Oh Crap app is something that you open up when you've been arrested. It tells, it can connect you to a bail bonds person. It can connect you to an attorney who could come and try to get you out of jail. It sells arrest insurance. I think it's how it's funded, is actually by contracting with the lawyers and by selling arrest insurance, whatever that is. So there are a range of things like that may or may not be legitimate, right? It may or may not be a consumer benefit, but this is a completely unregulated market if it's not the practice of law. There are several of them that have to do with traffic citations of different sorts. There are things like LegalZoom and Rocket Lawyer and Simple Citizen, which are helping you fill out paperwork with more or less lawyer backup, depending on the particular system. And then there are lots of Legal Match is one of a bazillion lawyer referral programs where you can go on and find the lawyer who's within 20 miles of you, who does whatever kind of legal work you think that you need. So there are lots and lots of these things. They are not demand driven, right? So they're driven by the sort of, for the most part, with a few exceptions, they're driven by the curiosity or interest of the people who create them. So there's a big mismatch between supply, the content of supply, and what people's actual known legal needs are, and their ability to use these tools. Most of them, you have to have good internet access to use the particularly sophisticated ones. Most of them require you to be able to read a lot of text, usually in English, and they don't do very much. And part of the reason they don't do very much is the rules about unauthorized practice. But part of the reason they don't do very much is that this sort of field, at least in the US context, has not developed very far so far. So if you think about people who are excluded from traditional services, they're also excluded from most of these tools that you see in the US context. So only about a quarter of them are available in languages other than English. We, of course, have millions and millions and millions of people whose primary language isn't English. They can't use most of these tools. Only about 16% of them can be used by people who either can't see text or can't read text. So any kind of visual impairment would make it challenging to use most of these tools. It's also the case that in the US, 1 in 6 adults is essentially functionally illiterate. So even if it's in English and that's the language that they speak, the information is not presented at a level or in a way that they're going to be able to make use of it. So, and those are the linguistic minorities and people who are poor and people who have issues with literacy are already shut out of existing tools, and they're shut out of many of these tools as well. The other thing you see is that the tools don't do much. So one of the things we know is that most people don't recognize the legal aspects of most of their justice problems. So people know that divorce is legal because it's actually a legal act, and they know that a will is a legal document because it's a legal document, but they don't necessarily know that their employer not paying them overtime is a legal problem, or that they're 2 months behind on some bill. They don't necessarily understand that that's justiciable in the same way. So one thing that would be very valuable would be helping people connect their life circumstances to diagnoses that lead to solutions. And so identifying the legal aspects of some situation that you're in could be one route to a diagnosis that leads to a solution. But very few of these tools do that. 2%, 3%. A few of them will help you collect and organize evidence. So JustFix is an example of one. There are some that allow you to record interactions with police, the idea being that you're then recording evidence that you might use later for a complaint against police. There's a bigger chunk of them that let you make a legal document. So they let you make a simple will. They'll help you fill out a form that state court system has approved as a divorce decree or whatever. There are about half of them will connect you to lawyers. And then there are a whole bunch of them that are just big encyclopedias of information about the law, typically not written in a very accessible way. So there's a lot of activity out there, but it doesn't really match our understanding of what people want or what they need if you're looking just at the technological side. So what would make these things more useful and also more used, or at least more usable? Well, one is that, at least in my system, you have 50 states plus the District of Columbia, each of which has its own court system. And then within that context, there are 3,000 some odd counties around the country, and they actually have their own court systems. So coordinating across all those different fiefdoms is very challenging. And even really strong leadership can't make everybody get in line, it seems, in the US anyways. And the other thing is that as effective as some of these tools can be, their effectiveness is structurally limited by our rules about the unauthorized practice of law, where in some states it's criminal, you could be prosecuted. In other states, you could certainly be sued. If you were a nonprofit, you could be sued into bankruptcy for trickling over the line of the unauthorized practice of law. And lawyers do this. So there was a workers' rights organization in Chicago that was helping people make unpaid wage claims against employers. And somebody filed and went to one of these workshops where you learn how to write the letter and file a complaint with the state labor board. And so this woman did that. And so then the employer hired an attorney, which is fine. And the attorney was going to defend the employer in front of the state labor board, which seems perfectly fine. But the other thing the attorney did was file a claim of unauthorized practice of law against the workers' rights group. So one case there, right, could have meant that the employer got to keep the wages for this particular worker, but shutting down the whole organization means you shut down the ability of this community to try to take action on its rights. So it doesn't just prevent the design of services, it prevents the sort of genesis of grassroots activity for communities that need access to the law. So this is a big block, at least where I live. And there's two rules that are sort of in the way here. So one is non-lawyer ownership, or what leads to ABS, or alternative business structures. Now, my understanding is that in Australia, you have ABS and have for 20 years. I think the largest publicly traded law firm in the world is in Australia, at least it used to be. So there are some states in the US that are thinking about relaxing this rule so that non-lawyers could have investments in organizations that produce legal services, that you could share fees with people who are not lawyers and so on. The other is the rules about the actual practice of law. So selecting, preparing legal documents, appearing in certain kinds of forums, giving legal advice. Could we relax those rules so that we could distribute a little bit more of that expertise to computer programs and people who are closer to ordinary people who have problems and need help? So what's new in the US context? Part of it is authorizing new kinds of legal services providers to practice law, and some of them are people, and some of them are computer programs. And then part of it is ABS, so allowing different kinds of practice structures that might be integrated across disciplines, that might be located in places where legal services are not located right now, so we would call it Walmart law. In the UK, they would call it Tesco law, so on. And then the other is fee sharing with non-lawyers. And so if you're thinking about it from an access to justice perspective, the reason fee sharing might matter, and we don't actually know, to my knowledge, we don't know the answer to this question, is that it's a route of access, right? So I go to the chiropractor because I've been in an accident and I don't realize that perhaps I have legal rights at stake here, and that person could refer me. And that would be a referral relationship between the lawyer and the chiropractor. And maybe that would get more people, for example, in contact with assistance when they need help. I think that's an empirical question, but that's part of the logic of this model. Now, why do we think this would work? Well, one thing we know is that if you ask people what they're looking for, they're very often looking for something that looks a lot like legal advice. So like a discrete part of what it is that a lawyer can do. One way to see this is, as I said, every state in the country has a website that's free and provides free information about the law and maybe free forms. And most of those websites at this point have a live chat function where you can type in questions and a human being will answer them. Sometimes the human being's a lawyer, sometimes it's a law student, sometimes it's a volunteer. That person, no matter who they are, cannot give you legal advice because they're not in an attorney-client relationship with you, even if they're an attorney. So I took the live chats from a period of time for two different statewide websites, one for a rural state and one for an urban state. And I locked some undergraduates in the room and I made them read the chats and then code them for what people were asking for. Were they asking for a referral to a lawyer? Were they asking for a lawyer? Were they asking for legal advice? Were they asking for information? And what you see is that in both contexts, the most common thing that people were looking for when they were typing in these questions was legal advice. And now my cuckoo clock has gone off and I can't stop it because I'm sitting in front of you. I apologize. Fortunately, it's only 3:30, 4 o'clock here, so it'll be done soon. All right, so when people go to these websites, they're looking for legal advice. They're sometimes looking for an attorney, but usually looking for legal advice. The other way to find out what people are looking for is to, with help from Nigel and Pasco, I did a survey in a middle-sized Midwestern community that was very much based on the England and Wales Civil and Social Justice Survey. And in that particular style of surveying, if somebody has a justice problem, you then ask them, okay, what did you do about it? Did you go to any of these different kinds of people for help? And if people went to help, you say, okay, so you say you went to a lawyer for help, or you went to a government office for help, or you went to a community organization for help. What did you want? What were you looking for? So you can ask them a whole, I wanted somebody to take care of the problem for me. I wanted to know what my next steps were. I wanted to know what might happen, so on. If you ask people, what were you looking for when you went for help? You see, again, sometimes they want someone to take it over for them. They want to be represented. Sometimes they want to be referred to the place where somebody can help them. But actually, the most common thing they want is legal advice. So if you look at attempts to get help from anybody, so from friends and family members, from neighbors, from government agencies, from formal sources as well, half the time what people are looking for is legal advice. If you look at attempts to get help from formal sources, so this would be going outside your immediate social network to some kind of organization or professional or agency, 65% of the time people are looking for legal advice. So it's clearly something that people want. And distributing expertise is a great way of opening up sources of legal advice. The other thing you see is that this is true in many countries, including Australia, but in the United States, there are a range of government tribunals where non-lawyers can appear and actually represent you in a particular type of hearing. And when those folks are, this has been possible in the US for 60 years in state tax courts of different kinds and federal benefits tribunals and immigration hearings. What you see is that when those kinds of non-lawyers are available, people will use them. So across the settings where this has been studied, they usually provide a fifth or more of all of the representation available in the space. This is even true when sometimes the lawyers who are working in the space are eligible to be paid by a cut of the back benefit that they get, but the non-lawyer is not eligible to do that. So the fee structure is a little bit different. But nonetheless, you see that there are plenty of people who are willing to use these non-lawyer providers when they're available for use. The other thing you see is that the more it kind of makes sense, if there's only one door to get in, everybody has to figure out how to find that door and open it. But if you create lots of options, lots of routes into figuring out what kind of problem you have and how you might take an action on it, people are more likely to do something than if you just give them one choice, which makes them more likely to do nothing. And one way to see this is to compare two jurisdictions. So let's think about a jurisdiction that has really restricted civil legal aid, so it's only poor people and there isn't enough of it. And then you have really strong rules about who can practice law, so there's lawyers and basically not much else. Let's compare that to a jurisdiction that has much more expansive legal aid. So this would be a place where into the middle classes, you might get full subsidy for your purchase of legal services. You might get partial subsidy, but you're getting some kind of help. So it's much easier to connect to legal services. There's a legal aid bar that's out there waiting for you. And then there are not such strong restrictions on the unauthorized practice of law. So you have lots and lots of alternatives to lawyers who are empowered to do part of what lawyers can do. So if you go to this restricted context, which would be the United States, and these data come from 1992, but it would look just the same right now, and in fact does look just the same right now. What you see is that these are people who have money and housing problems. About a quarter of them do nothing at all about their problem. About 2/5 do something on their own. This is very common. It's usually the most common way that people resolve justice problems. Another quarter will go to law. So they'll either file a lawsuit and try to handle it on their own, or appear in a lawsuit on their own, or they'll actually go to an attorney. And then 8% go to a non-legal third party. Well, the non-legal third parties can't do anything, so why would you go to them anyways? Well, so let's compare this to the United Kingdom, or to England and Wales. in the early part of the 20th century. So this was before the super massive cutbacks to civil legal aid. So there was still some subsidy going up into the middle classes under Judicare. And there you see again, almost half of people handle things on their own, which, as I said, is a very common pattern across different kinds of places. But only 5% of people do nothing at all. And I would suggest that's because there are lots of options for ways to take action. So you've got 36% of people going to non-lawyer third parties like the Citizens Advice Bureau and other places where people are empowered to at least give you a sense of the situation that you're in and what your options are, and maybe give you some guidance about which way to go. Only 10% of these money and housing problems were going to law. And that's in a context in which law would be free for some chunk of those folks. So it's really interesting. It's not just that if you have more doors, more people can get in, which makes sense. But if you have more doors, sometimes people don't want the big door with the shiny attorney behind it. Sometimes they want a more refined take on their problem. They want to keep control of it in different ways. They want to maybe have a cheaper solution, etc. So more options, more action. The other thing we see, and this also, some of this very best work, first of all, was done by Nigel and Hugh and other folks at the Victoria Law Foundation. And a lot of this best work comes out of England and Wales and Scotland. This is a study. So when they were getting ready to do all the big cutbacks in the UK on legal aid, they wanted to do a study that would essentially tell them whether it was okay to sort of route people away from legal aid attorneys to these non-lawyer providers of different types that are permitted in this jurisdiction. And so they did a big survey where you have experts audit case files in a range of different civil areas of law and compare the work of solicitors, so office lawyers, to these non-lawyers who are specialized in different, in debt or in employment and family or whatever they might be working in. And you see some really striking things. So the way the audits went was, sort of, did you fail? Did you pass? Did you excel? So below threshold competence is failing. What you see is that everybody makes mistakes. So fully qualified attorneys make mistakes, non-lawyers make mistakes, and they make them at about the same rate. And every study like this I've seen, it's 20 to 25%. Both the lawyers and the non-lawyers screw it up. But that of course means that 75 to 80% of the time, they're doing a solid job, both kinds of providers, both lawyers and non-lawyers. The thing that's really interesting in this study by Richard Moorhead and his colleagues is that if you look at that excellent work, the non-lawyers were about 6 times more likely to do excellent work than the solicitors were. So it's not just that there's clearly a body of cases for which non-lawyers can totally solidly do this stuff, but that probably because they specialize, they can often be better at it than general practitioners who are more scattered in their experience and in their focus. So in the United States, drawing on these findings from other parts of the world, but also drawing on, at least in my context, we're still very neoliberal. I'm not personally, but like the country is still very neoliberal, and it's still very much looking for market solutions. And so there are a range of experiments starting around the country that relax some of these restrictions, the restrictions on non-lawyer investment and the restrictions on non-lawyer practice. And the logic of these is a market logic, but the goal of them, at least as expressed in public, is always access to justice, that we can increase the number of people and increase the equity in who is able to receive the assistance they need when they face civil justice problems. So we're trying these experiments, and then when will we know whether this was a good idea? When will we know whether this works? Well, the experiment that's farthest along is in the state of Utah, which, if you've never been to the United States, is sort of in the west central area in the center. It's a state that has beautiful mountains and amazing canyons, and if you like western terrain, it's a really beautiful place to be. It also has a very edgy state Supreme Court. So in the US, it's state Supreme Courts sometimes working with the bar that regulate legal professions. And so this state Supreme Court has created the Office of Legal Services Innovation, which you can apply to provide legal services in ways that violate those longstanding rules. So you can, one or both of, have non-lawyer investment and ownership, or non-lawyer practice. So the non-lawyers could be people, or they could be computer programs. So you apply to be regulated in this space, to do things that are not permitted anywhere else. And it's an evidence-based regulatory scheme, which if you're a researcher is awesome because it means it has to collect evidence, and then you can look at that evidence for a range of purposes, including consumer protection, which is the goal of this particular regulation system. So the way we set this up was we focused on three harms to consumers. That's the sole thing you're trying to prevent in this particular framework. So does the consumer get a wrong result or an inappropriate legal result? So a legal error. Another kind of legal error, does the consumer miss out on the exercise of a right because they don't understand or someone tells them to do the wrong thing? And then finally, did they buy the wrong thing? Did they buy a service they don't need? Did they buy an inappropriate service? Upselling would be one example of that. So when any entity applies to come in here, their risk level is assessed. And the people who work in this office, of whom I am one, will be very honest that we don't know what is risky or what is not risky based on evidence, because there is no evidence base at this point. So the way risk is assessed is essentially how far do you depart from the traditional practice of law. So there's a bankruptcy firm called Blue Bee Bankruptcy, where the guy wanted to give his paralegal a 10% ownership interest in the firm to thank her for her hard work over 20 years. Okay, minority non-lawyer ownership, nothing else is changing, that would be a low risk entity. But once you start having majority non-lawyer ownership, that's a moderate risk entity. Once you start having non-lawyer people or non-lawyer computer programs doing high-level legal work, by which I mean giving legal advice, filling out documents in an intelligent way, that becomes a higher risk activity in this framework, because that's all we know, is just how different it is from the current practice of law. And then if you're admitted under your risk assessment, you're monitored on a regular basis, providing information about the services you provide, the amount of money that you're charging for them, and so on. The higher your risk assessment, the more frequently you have to report. So if you're low risk, it's quarterly. If you're high risk, it's monthly. If you're higher risk, you're subjected to audits and secret shoppers to compare, to make sure that your computer algorithm, for example, is not leading everyone astray, and so on. Since August 2020, which is when this opened, the sandbox it's called opened, there have been 18 entities that have moved in. That doesn't sound like a lot, but Utah is a small state. So you're talking about a state that has 3.2 million people and 9 or 10,000 lawyers. So this is not California or New York. But 18 entities in a range of different civil fields. They're not allowed to do any criminal work except for expungement. So in our system, that is a civil thing you would do as the result of criminal justice system involvement. So a range of different kinds of civil areas of law. Now, if one of the goals of these kinds of experiments is to make a dent in the access to justice gap, that is to provide some assistance to that huge mountain of people who are not receiving any help, one thing to think about is how long would this kind of change take to show an impact that we would notice? So with some colleagues, James Tufel and Tom Clark, who are both in this office, we estimated the number of unserved civil justice problems that poor Utahns and middle-income Utahns and the owners of small businesses experience in any given year. It's almost 2.5 million. Justice problems of varying severity, of varying type, but they currently receive no legal service of any kind. So if that's the sort of, if that's what you're trying to make a dent in, when would you notice that you're making a dent? Well, right now there are something like 500 service contacts that have happened since August. So this kind of activity is slow to ramp up, particularly in a small state. We could serve 8% of this need with a 60-fold increase in the current activity in the sandbox. And if you're moving to something like a third of that need, that's a 240-fold increase. So most of these experiments in the US have a 2-year time horizon on them. There's no way that you can answer this question. If we create this new ecology of services, can we make a dent in unserved need in 2 years or 3 years? So one of the things that that these regulators need to think about is, can we have a more realistic time frame for impact? If you're thinking about what would bring, since these are market-based innovations, if you're thinking about what would bring investors in, investors, if you're doing something truly new, you will lose money regardless of what you're doing for at least the first year. So investors want a bigger time horizon to do totally wacky things in this kind of space. So it restricts both our ability to see what's happening, but also our ability to allow things to happen. So I think in terms of assessing progress, I hope that in my jurisdiction, at least, that policymakers can be patient. If you look at these models that are evidence-based regulation, consumer harm is what they're focused on, and that's monitored continuously. So we can know pretty quickly if there are bad things that are happening, but it's going to take a lot longer for us to notice if good things are happening. That is, if there are really big changes in the way this affects the case flow of courts, or the ability of ordinary people to resolve their justice problems, or the ability of small businesses to resolve their justice problems. But it's in a very exciting set of developments, and I look forward to your questions and to the conversation. Thank you very much.
Thank you, Becky. I hope I'm off mute. Yes, good. All is well, and I'm really thrilled we got to hear your cuckoo clock, because it sounds it situates us perfectly in your home. So that was delightful. And I also know that there are going to be some mornings where I wake up and that image of a sloth sitting on top of a turtle or a tortoise is going to be exactly my mindset. So you've given me some great visual imagery as well. There are so many dimensions to this, and we've got a number of questions coming through, and I invite everybody watching to please put your questions in the Q&A function, and also to upvote some really strong ones that are already there. But if I can just start with the first thing that came to my mind as we heard your presentation. This process, as you've just described, is going to take a long time to show any efficacy or any impact on what we've already identified as the massive submarinal iceberg that is unmet legal need in the civil space. But can you take us on a little bit of a journey around the path thus far in the US in getting to this? Has it been an advocacy effort over 50 years or something to start breaking down the monopoly of lawyers and to introduce a broader range of options to people to open more doors, or has it sort of picked up momentum more recently? What's the sort of pace of it?
So it started probably in 1999 on the corporate side, when consulting firms and accounting firms wanted to get together with law firms and kind of provide wraparound services to big corporate clients. And the US bar voted that down. They said that was a terrible idea. We should absolutely not do it. And then 2 years later, of course, Australia, and then a few years later, the UK said, sure, let's do it. What the heck? So what happened was that changed in other parts of the world, and big law firms are global now, so they know that they have to compete with organizations that can do other stuff in that big law space. But technology also changed very fast, and that allowed things like LegalZoom and Robot Lawyer to start to both unbundle human lawyers' services, because that's that little guy who gives you advice after you fill out your will, but also to automate it. And I think that made at least Supreme Courts, thinking about their role as regulators, think that we've got to figure out how to do this. It's also the case that, at least in the US, you have this continuous pullback of central government. So we never had, after the Great Depression, we had a welfare state, but it was never like a European style welfare state. It was just kind of an American style welfare state. And since Ronald Reagan was president, that's gotten smaller and smaller and smaller and smaller and smaller, because we want markets to solve these problems. That's sort of our political logic. And these kinds of changes resonate perfectly with that market logic. Right? So you can say, well, these rules prevent innovation, and they prevent consumer choice, and they're anti-liberty. And so if we release them, then people can do wonderful, innovative things and be productive and make money that we can tax, but then they'll produce all these wonderful services that will create this ecology that people who are currently excluded from the existing ecology will rush into. So it was sort of it is a more recent thing. It was partly facts on the ground and partly the kind of rhetorical moment that made it possible for these kinds of experiments. If you see where they're happening in parts of the US that are historically anti-regulation. So the West is a very kind of free sort of place. Utah, which moved first and is the kind of the edgiest, is also very small. So if you have a few really strong leaders in a state like that, then they can make a big difference because they can go around and actually meet with everyone. The really interesting one that's in play now is California, which is trying to figure out how to do this. Now that's 60 million people and the world's 5th largest economy. And so it's a much more politically complex process than a small place like Utah. But if that flips, I mean, if any of this happens in California, that will be, I think, a game changer for most of the country.
I think it's fascinating that this is sort of emerged from the commercial sphere, but that's another long and interesting story. Let's go to some of the questions that have come through the chat, Becky. One which I think very many people are keen to have your insight into is whether or not there have been tools, digital tools, that have supported people, particularly those with disability or who are functionally illiterate, that you're aware of that have been effective. Are there examples that you can think of where that's worked?
So there are 3 that come to mind. So and the way they make that connection with populations that can't use traditional services but also can't necessarily interact very well with the tools is by having human beings. So they have community organizations or other kinds of service providers that are helping people connect with the tool. So one is a program called Risk Detector that's sort of put out by a company called Pro Bono Net. And what Risk Detector does is it connects social workers and attorneys around issues of financial exploitation and elder abuse. And so if you have if in our jurisdictions, if a social worker is doing a home visit or a community health nurse is doing a home visit, they already have this battery of assessments that they're doing. Can you manage what you have to manage in your house by yourself? So adding 8 more questions for the short version or 25 more questions for the long version is something that fits right into the existing structure. That Risk Detector, it calculates a score based on the questions and it ships that score off to the partner legal aid organization. And then the lawyer can say, can call the elderly person and say, it looks like this is what's going on. Would you like some help dealing with your nephew who it seems like maybe is exploiting you, or dealing with the scam that you maybe have got involved in? So that one seems to work pretty well because it's embedded in existing relationships between community health nurses and social workers and legal aid providers. There's another one, Just Fix is another great example. So that's the one that started out by writing a letter to your landlord. It now will file the lawsuit for you in the housing court. It also has a program called Who Are the Worst Landlords in New York? So they don't give legal advice, they do what's called data-driven onboarding. So New York City has great public data laws. So the city's complaint function, which is called 311, is a public data set. All of the property records are a public data set. So the folks at Just Fix have made a database that tells you, does this landlord evict a lot of people? Does he have a lot of harassment complaints? Does he have a terrible repair record? And so when you go in to do that first thing and write your letter to your landlord, based on your address, it will push up things like, okay, if this happens or this happens, that's harassment. And we can help you with that. Or if you receive an eviction notice after this, this is the next thing that you should do. And what information you receive is keyed to the place where you are. So it is a form of legal advice, but they call it data-driven onboarding because that then keeps them out of trouble with the bar. So that program is distributed through tenants unions, through different kinds of community organizations. And then the other thing you see is that often elderly people are not super comfortable using these tools. So Just Fix has a grandparent program. So here, take this to grandma and show her how to use it. The others that have been very effective are around immigration. And those are usually in a bunch of different languages. They're about figuring out what status you can use to regularize your presence in the US. And they either connect you to lawyers if you need them, or they're distributed through different kinds of immigration rights organizations and community organizations. So they're through big workshops in libraries, for example, where there are people there who can help you and so on. But I mean, the thing that's common to all those is the relationships that they connect are already there, because technology doesn't make relationships. And then there are people involved all the time to assist folks at the different points in their steps.
Which takes us to a question that sits beneath a lot of my thinking around this. And it is to that point of diagnosis of a problem as legal, which you alluded to earlier. So you've got the social worker sitting talking to the elderly person about their life circumstances and whether or not they're managing at home. And the alerts start to go off, the flags are raised around whether or not there are other issues which might be determined as legal. So once again, there's a sort of human interaction to alert somebody, the person at the center of this, that they have a legal problem. So, I mean, it seems to me that there are wonderful opportunities for non-legal or non, the limited license type approach or the tech response. But you still need to know that your problem's legal before you get to that in lots of circumstances, whereas this is making that link for the person at the center.
Yes. I mean, that was the great thing about something like Just Fix is it doesn't say, what about the implied warranty of habitability? It says, there's some problems in your apartment that you would like your landlord to fix. We can help you with that. I mean, I think people experience these things as problems. And so if you build your solutions around problems, people are much more likely to connect with them and use them and find them effective.
Which brings us to a great question from another of our attendees. Why are non-lawyers so much cheaper? I mean, you mentioned it at the beginning of your remarks that court navigators and other people who are social workers and working in that space, that scheme can operate a lot more effectively because it's a lot cheaper to run. So it is a lot cheaper to have non-lawyers in that space. Is it because they don't have the income expectations, or are there other reasons why that is cheaper to run?
Well, I think part of it is, so in the US, law is a 7-year degree. So you have to have a college degree and then you go to law school for 3 years and then you become licensed. And so people leave that with $100,000 to $200,000 US dollars of educational debt. And so they can't go into this line of work without making enough money to be able to at least carry that debt. So that's part of it. But another part of it is there's a wonderful, if anyone out there is interested, there's a wonderful practice management software company called Clio. That's, I think, out of Vancouver. And they do a wonderful trends report every year where based on the data that they collect from their customers, they tell you about how lawyers practice law and how they spend their time. And lawyers are astonishingly inefficient. So they do billable work 2.1 hours a day. And the rest of the time, they're doing other stuff. And so if you think about a social worker doesn't have to manage a law practice and do whatever it is that's taking lawyers all this time. They just have to know how to do the in-court part that they need to know, and then the out-of-court part that they need to know, and that's all they do. And so it's just a much more efficient model of service provision focused on the work that you're actually doing, rather than building out a big practice that has lots of other things going on.
We talked, or you mentioned earlier, that the sort of the monopoly of the law, and I think even though we have publicly listed law firms, there is a rump of resistance, perhaps bigger than that too, in Australia around breaking down the monopoly of lawyers for this sort of legal work. So is there, I mean, I was interested that you mentioned the sort of layering of data and how different data sets can be used to identify particular issues in particular neighborhoods. And that seems to me to be a workaround in sort of getting to non-legal response, but using tricky ways or smart ways to get there. how effective is the chipping away at the edifice of legal practice? I mean, you've pointed out, it costs a hell of a lot to become a lawyer. There are a lot of people who want to do it for various reasons. Can you foresee a time when that won't be such a challenge to getting legal support and solutions for ordinary people? That it's just people, vast majority of whom are priced out of the market.
I think, and this has to happen in Victoria as well, there are already a whole bunch of unauthorized providers working. So in the immigration space, we have something we call a notario, some of whom are criminals and some of whom are really effective at helping people move through the steps of paperwork. There are all kinds of legal document preparers. There are all kinds of paralegals practicing independently who aren't supposed to be. Many of them do very good work. Wouldn't we like to have that in a regulated space? I think that's one of the things that's moving on to the radar in the US. I think if you look at the objections in our bar, it comes from two different places. One is people whose practice is so document heavy that they can see the writing on the wall about automating stuff that really should be automated anyways. It just happens to be a large part of their practice. And the line that we always tell them was, well, wouldn't you like to practice at the top of your license? Let the computer do the clerical work and you can practice law. I'm not sure how persuasive that is, but that's the story that we try to promote. The other part of the bar that gets very unsettled, and this is around referral fees, is there are already established relationships through which established lawyers get their work. If you change the way people can refer clients to each other, that unsettles that, which is the whole point of these reforms, right? It's to unsettle the way we do things now. And so that part of the bar, the personal injury bar, which was paid by contingent fee, is very resistant to this. But there are other lawyers who recognize that, so if I can employ one of these paralegals to go into a segment of the market where no one can afford me, but they can afford that person, then I can have a partnership with that, and my market has just expanded. And maybe some of those clients will move up to my level and pay my full freight if they need, full representation or something. So there's another segment of the bar that sees this as an opportunity. Whether we're at some inevitable tipping point, I doubt it. I mean, my sense of these things is that it really requires a lot of persistent effort by a range of stakeholder groups to push this particular rock up the hill, because we've been, at least in the US, bashing our heads against this wall for 80 years, trying to do the same thing over and over. And so they sound like dramatic changes, but they're fairly incremental in implementation, because people are very risk averse about doing something crazy like letting non-lawyers practice law. And so keeping those things moving forward and being able to show nothing terrible happened, I think is that's the activity of this moment, I think, in the US anyways.
And surely there's also the sort of consumer protection dimension that you've alluded to in terms of regulation, that that there aren't sharks dealing with immigration who are going to send you off in a direction that is both expensive and completely ineffectual. So is there much response from legal regulators around trying to embrace a broader remit?
I think they're very curious, but in terms of states that have actually done anything, there are only two. Utah, which has this experimental space, and then Arizona just got rid of the rules. Okay. It didn't get rid of the unauthorized practice rules, but just got rid of the non-lawyer ownership rules. Said, forget it. And then they're doing the unauthorized practice stuff a little bit more selectively. But everyone else is kind of hanging back to see what will happen, I think.
Yes, I think we're probably in that boat to some extent too.
Can I just ask on that, whether this experiment in Utah is getting a lot of publicity outside of Utah?
It is, particularly in the legal press, because it's releasing these two very long-standing rules that are perceived to be protectors of ethics, right? They're like, they are the source of good behavior and consumer protection. So there's a lot of conversation in that sense. Where there isn't conversation is in the communities of businesses that could be making up new stuff to do in Utah. right? So lawyers are very conscious about this, but all the new providers you would want to come in have not figured this out yet.
Another question has just come through, Becky, which is a really on point, I think, in terms of the tech advances. Not so long ago, there was a period where it was clear that we were about to, suffer death by apps. There were just apps coming out left, right, and center, and so many of them I don't think didn't take off at all because people didn't really know they were there or know how to use them or whatever. But I think the market is continuing to develop, and Sam's posed a really sensible question about whether or not there is sort of central space or some kind of opportunity to exchange ideas and best practice around the efficacy of some of the tech responses to the law. I mean, given that every jurisdiction is different, but tech operates very largely in similar ways. Is there somewhere that people are sharing this kind of insight?
So there would probably be two places. There's a thing called the Self-Represented Litigation Network, SRLN, and it has a legal tech group, which is entrepreneurs and core people who are trying to figure out what the best tools are and how to use them. I think also Stanford University, in a partnership between its design school and its law school, led by a woman named Margaret Hagan, has some really interesting projects going about how people talk about legal problems on Reddit or how they ask about them on Google. So then could we go back to those providers and say, please redesign your algorithm so that it does this and takes people in a more useful direction? But there isn't a central space. I mean, there are meetings, of course, but there's not a central space where people are sharing, in part because if I'm an entrepreneur who wants to make money off of this, it's my secret sauce. So my incentives to collaborate are maybe not the same.
Yes. So there are those of us, I suppose, who are coming at it from the sort of, access to justice perspective, and then those that, I suppose, understandably have a commercial motivation sitting behind it. But yeah, that makes sense. Margaret comes to Australia, or used to, when things were possible, every now and again. So she'd be very familiar to many of us and to many of the people watching. But it is, I think, it's interesting to watch that turn, and that the tech has been, I think, it had its initial phase of explosion and has now kind of retreated a bit and is probably iterating more sensibly. And we hope that results in reasonable impact. But there are so many dimensions to this. There's a regulatory bit, there's the tech bit, there's the willingness or otherwise of legal practitioners to engage with this stuff. There's the service system that sits around it. It is the need for all of those threads to come together in some sensible form that will push that rock up the hill, isn't it? And we just haven't quite found that formula.
Well, and I would say that the market is not that form. I mean, the market can create a space that incentivizes people to do new things, but it doesn't create a space that incentivizes the state court to accept the document that you submit, right? So there's sort of these very fundamental coordinations between different pieces. Something else has to make that happen.
What's the something else?
Well, so in my jurisdiction, it's state by state. You have to get all those stakeholders on board that that's what they want to do. In places that have a central government, I imagine, maybe I have this dream that central governments do this. I don't know. What would make it happen in Victoria?
Yeah.
Is it that disintegrated, or?
Well, I think it is an emphasis on understanding what the problem is that people are trying to solve. I think it seems to me there's probably in different people's minds a different comprehension of what it is they're trying to address. And as you alluded earlier, this lovely big banner of access to justice gets used and perhaps misused in a variety of ways when it suits people to park their project underneath it, and whether or not they mean the same thing as the person down the road is something else altogether. And I think government will, there's no question that commitment from government and a real determination to see that through, especially in the civil space, which is particularly tough because of the sort of huge diffusion of issues that takes in. So yeah, I mean, it's the toughest challenge because, as we've all discussed, you know, civil legal issues are everyday issues, problems that people encounter. Nigel, what's your view then on the Victorian context? Do you reckon we've got any kind of cohesion?
I think I'm going to hold back on that till we have some results from Pulse, and then I'll let you know all about the Victorian context. Yeah, I mean, I think we're probably facing some of the issues similar issues that Becky's talking about, for sure, though. I was wondering whether Becky might be able to talk a little bit more about the court navigation project, moving a little bit away from the tech. I saw there was a couple of questions around that. There was one question around the size and numbers associated with the social work component. I'm kind of more interested in the absolute sort of simplest service they provide. So, you know, just the pure navigation without the social work. Do you have any evidence of what that does and how effective that might be? And there was also another question coming directly from Court Network about how volunteerism is viewed within the navigator context. There's a few bits on that.
So when New York City did its navigator program, it had 3 different types. And the most heavily volunteer-based type was called an access to justice navigator. And that's what they were. They helped you figure out which room you were going to go to next, what this paperwork was. And they worked in debt collection cases, which turned out to be really impactful. And then they also worked in eviction. And certainly people who had contact with them in evictions felt better about their experience. In the debt collection cases, they would go meet with, so in the US, hardly anyone who's responding to a debt collection claim has an attorney. And the attorney from the other side comes in and says, you owe all this money, here's some papers. What most people don't remember whether they owe the money. They think maybe they owe some money. They feel kind of guilty. What they don't realize is that you can force that debt collector to prove that that specific amount is what you owe, which they almost never have the documentation to do. So the navigators, who were these little college students, would say, well, why didn't you ask him for the documentation for that debt? And so they started dropping their cases at enormous rates simply because it was just a process issue. People now understood that they could ask for certain kinds of information from the other side. So I think it can be incredibly impactful if it's focused on that precise kind of thing. There was another kind of volunteer navigator that when you get an eviction notice, you have to go stand in a line and file an answer. And so these people would wait and they would grab you while you were in the line, and then they had a script and they would take you through the possible defenses to the eviction and ask you which applied to you and help you fill out the form, and then you would give that to the clerk. So people who had help from that type of navigator, who again is just a college student with a little bit of training, raised twice the number of defenses as people who didn't. And if they raised those defenses, the judge was twice as likely to note them in the resolution to the case. Doesn't mean that the tenant got what they wanted, but at least it became part of the conversation that the court had about the case. So people were able to participate in their cases more effectively. And again, they have to be supervised and they have to be trained. Someone needs to be on the floor for backup or available for backup. But otherwise, they can be quite effective at these very focused activities.
I think the second question that Nigel had there was about the volunteer dimension to this and whether or not that was, and it's certainly the question in my mind is how sustainable that is as a way of supporting justice.
So if you look at the way most of these programs are staffed around the United States, there's a woman named Mary McClimate who out of the Center for the Legal Profession at Georgetown did a report. It's kind of a landscape survey of navigator programs for the US, came out last summer. The vast majority of them are staffed by volunteers Sometimes they're retirees. Sometimes they're college students who are getting service learning credit at school. So if you can set up a relationship with a college, you can get a flow of those people over time. We don't have national service, but we have a program called AmeriCorps, where you can apply and be accepted and get paid a poverty. It's literally a poverty level wage, so you're eligible for food stamps and things like that if you're in AmeriCorps. But that staffs a lot of these navigator programs around the country, and it's sustainable as long as that federal funding subsists to keep them. The big thing, the complaint about the folks who work with volunteers is that just about the time they know what they're doing, they move on. They graduate, the class ends, whatever. So it's hard to keep this kind of continuity of expertise with that model. But our courts don't have the funds to pay those people, so they have to rely on these kinds of solutions.
Was that the second part of the question, Nigel? Yeah, cool. So the whole flow, I think, of access to justice in the broad brings us to this, fundamental question around and I know I'm going sort of very highfalutin here, but whether or not the state gives a damn about people's sort of general life experience and the legal dimensions to that. I mean, we hear a lot of rhetoric about the critical importance of the rule of law, and boy, we've heard it in Australia over the last couple of weeks in another context. And everybody's noble commitment to that. But when it comes to boots on the ground, as one of your former presidents might say, it's just not evident. And maybe I'm expressing a sort of existential angst about this stuff, which is probably doesn't quite fit with my exposure to your world. But I'm impressed with your energy, Becky, and your commitment on going to this. But do you get despairing at all that this is, never really going to crack a nut?
I used to be despairing when the line for expanding access to justice in the United States was more money for legal aid and more pro bono, more volunteering from lawyers. And I think those are both great things and we need them, but there's no way you can solve this problem through that route. And so I am not really a capitalist. I would like to live in a Swedish style welfare state, but I don't. I live in America and we believe markets fix everything. And so these market-based reforms are an opportunity to create new access to justice that's politically possible at this moment in history. And so that makes me somewhat less despairing. One thing I will say, though, is in my free time, one of the things I do is try to find ways to get nonprofits into that space in Utah. Because if you set up a market-based reform where the incentive is to come in and make money, if I'm a domestic violence advocacy program that's already totally oversubscribed and probably already practicing law anyway in a quiet way that the court is accepting, why would I want to come into this space? I can continue to do what I'm doing anyways. And so finding ways to increase the capacity of nonprofit organizations to get interested in this, to think about what they could do, and then to come in and design a sustainable service, I think is a big challenge with these kind of market-based reforms.
Have you found ways to do that, to make that look attractive?
So we managed to get a small foundation called Bigglesworth to give us a grant for essentially a midwife for nonprofits to come in. So here's how to design a service, here's how to make it sustainable, here's how to make it through the application process. So we hope that will get some in. But I think it's a big challenge.
Very. Nigel, did you have further thoughts? Because I think we're probably running to the end of our questions.
No, do we want to return to any of the questions we might have overlooked? Just scouting through them.
I may have not been reading quickly enough.
Yeah.
Oh, there's an online tool from Consumer Action. I'm just reading here from Katie. We know people have undertaken self-help to seek $30 million in refunds for dodgy insurance. This has also enabled some policy and advocacy work. One thing that boosted use of the tool was promotion by a non-lawyer, the barefoot investor, Scott Pape, who's a legendary figure in this part of the world. He writes best-selling books on how to, successfully sort of secure your financial future. So is there, I suppose, a way to attach some of these efforts to very high profile people who are very persuasive and very credible in a general populist way, rather than just attaching them to the sort of legal heavyweights that tend to divide or not be as universally appealing? Has that worked? Have you seen any efforts like that?
So I think that's the hope. I think that kind of advertising would absolutely be permitted in most U.S. states, but I haven't seen it happen yet. But we'll see.
Just on the 320 apps, and I remember when you produced that review, and I just remember being terrified by the sheer volume of them. Do you think as a whole they have a benefit to the public, or do you think they just make a complex system even more complex?
I think probably that all of those information apps just make things more obfuscatory and discouraging. I think it would be really interesting to know more about Reddit and Quora, where people go and they get advice from each other about what to do, and whether that, is that really a way of increasing community legal capability, right? These people they're using their experiences to help each other and to see things as actionable. I don't know that we know what the impact of those things are. The Margaret Hagan's work is mostly sort of just what happens there. How do people talk about it? But not do they, is the world different because of those things? But that seems to me like where the possibility is.
Which brings me to another, giant question, but something that intrigues me. When we talk about the need to make sure that people understand their problems as legal, is there any way to measure what the impact is of them not doing that? What is the impact of failing to recognize your problem as legal? I mean, I think we clearly have sort of anecdotal understanding of what that might look like for many people in really tricky circumstances. But is there any empirical measure of that?
Well, we can ask them if they have particular kinds of problems, whether they think those problems are legal. Nigel has done that.
But I suppose what
I've done
is what happens if people don't? I mean, so what's the sort of counterfactual, if you like, that people are, that their lives are made much more difficult. I mean, we talk about this as the obvious sort of anecdotal response, but I just wondered if there was any kind of empirical evidence of what happens if you don't diagnose your problem as legal and you don't get any legal support.
Yeah, so it comes back to that most obvious of research findings, that if you don't see your problem as legal, you don't get legal advice.
But what's the impact of that?
Well, that takes you down a route of, well, what impact does legal advice have? Which, as Becky will probably tell us, takes us straight to work done in Harvard with Jim Greiner and such. Yeah, but generally, as far as we've taken it, is, well, if you don't see your problems legal, you're unlikely to get legal advice. So we might have to rethink how lawyers are doing law if we want people to access these things. But the broader, well, what impact does it have not getting legal advice, takes you down a different route, of which Jim Greiner is the sort of leader.
And there's another part of not getting legal advice, which is, I think I'm less personally, if I were a policymaker, I would be less concerned about whether or not people see the legal aspects of their problems and that they identify them as things that they could work on or find some solution to. And so law is one route, right? So if you can recognize that there's a legal problem, then you have this list of possible solutions. If we could design systems where people didn't have to make that connection, that would be even better. If you just stumbled on, go ahead. Sorry.
Sorry, Becky. I absolutely agree. You don't get a lot of bang for your buck trying to educate people about, how to see things as legal. It seems far more efficient to build an infrastructure where you never have to see that. Is the simple point.
So that's more about getting the law to see issues as problems, as opposed to the other way around, getting people to understand what the legal dimension is.
Well, and if you're in the US, we've got 320 million people and about 1.3 million lawyers. So I would rather change 1 million people's mind than 320 million people's minds. It just seems like a more effective route to change.
Indeed, absolutely. I think we've probably come to the end of the questions. If there's anyone who quickly wants to jump in with a question, then please go for it now. One, I think, from Will, is there a responsibility in the way laws are made and what can be advocated for to make the rules of the system less baffling for the average user? I think that's a really interesting one. So what do laws look like? Has that crossed your radar at all as to how complex legislation and law is to grasp?
Again, do we really want people to understand the statutes around housing conditions, or do we want them to be able to take actions when their roof is leaking? And so the most effective, I think, efforts in that direction that we see the substantive law matters because it makes things more or less possible. Right? So if there's no law that says landlords must maintain premises, then it's not possible to force that, right? So that's substantive law matters. But if you instead of making someone write a pleading that cites statutes, you say there are 6 possible defenses to this eviction, check those that apply. It makes it much easier for somebody to engage around their own problem. So that you see a lot of plain language, simple forms, and that I think can be very effective. But because it doesn't require me to know the law, it just requires me to know the next steps.
So there's a translation piece in there that somebody undertakes between the statute and the plain language, but that's not what the consumer needs to deal with.
That's what I think.
Yeah, that makes sense. And another final question, I think, from Kim. Discuss your thoughts on data collection and the potential lack of clarity regarding systemic issues. I'm not entirely sure I understand exactly what that's getting at, but does that resonate for you?
So I just turned off the clock.
Oh, sorry.
Now.
I was about to go again.
Try that question again.
So this is around data collection and potential lack of clarity regarding systemic issues. So I think that's about how we would paint the picture of particular issues through data and whether or not there's a mismatch there or a potential manipulation or skewing.
I think that's a great question. One of the most important resources we have for understanding the justice gap, for understanding some of the questions that we've been talking about today, are paths to justice style studies of people, right? So the VLF is doing one right now, and Nigel was talking about it, because that gives us a picture we can't see anywhere else, because those people may or may not have come into contact with service providers or law or whatever. So that's very important. I think that we also want to know, though, about the service providers and courts and so on. And at least in my jurisdiction, almost none of that information is available. Compare it to, so we can calculate an unemployment rate. We can calculate a high school graduation rate. There are basic facts like that around civil justice that in the US you cannot calculate. So we estimate based on surveys of 5 courts what the rate of unrepresented litigants is in family cases, but we don't know. That information is not collected and made available. And so it becomes very difficult to point out systemic problems. So in the US, and now recognized around the world, we have horrible problems with systemic racism on the criminal justice side. I would guess that we have parallel problems on the civil justice side. There is no way to document them because we don't collect the information necessary to do it. And I think that's part of why there's been so little action on the civil side. It's hard to outline the problem because we don't have the evidence.
And hard to make the case to those who might be in a position to make significant change if you can't present the evidence. It's a bit of a difficult spiral. I think that is actually, given where we're at the Law Foundation with our work, the perfect spot to wrap our conversation. But we promise that there will be a whole lot more data once Pulse is done. And Becky, we thank you again for your contribution to the Pulse work. very exciting times. And for all our attendees, we'll keep you well apprised of where we're up to with Pulse. Nigel, did you want to make some closing remarks at all?
I will just briefly say on court data, not wanting to just advertise all of our projects, that we're also currently doing a project which is led by Hugh on using utility of administrative data in courts and tribunals in Victoria too, and I not wanting to anticipate what Hugh's going to say, I suspect we'll see many of the barriers that you're talking about.
Indeed. For those of you who didn't quite get that, because I think Nigel's connection wasn't great, this is the data mapping project. We've produced the first report, which looked at the legal assistance sector. The second one on courts and tribunals is forthcoming, so keep your eyes out for that. And as Nigel pointed out, that does go to a whole lot of the barriers that we're encountering and that I think are universal pretty much in terms of how people get the responses that they need in order to resolve the problems that they have in their lives. Becky, a great pleasure to see you distantly. We look forward to an in-person encounter in the not too distant when bubbles permit. And thanks again for you and the Cookie Clock.
Thank you for the opportunity to be here, and thank you for your tolerance of my cuckoo clock.
Delightful. Nigel, thank you, and to the Research Network team, to Neil and Claire who make these events possible, and to everybody who attended. We really appreciate you joining us, and don't forget to tell your friends. There will be a recording of this available to you if you'd like to see it again or to pass it on to people who may have missed it. And stay tuned for our next research event. I'm not quite sure when that is. Sorry, Claire, I haven't got the details in front of me, but there will be full communication to let you know so that you can sign up for our next Research Network event. Have a great day, and we'll see you soon.